Thank you. Welcome, everyone. Thank you for joining us today. This is the first webinar that our group, the Consumer Financial Services Subpractice Group, is offering. So we're really excited about this and happy that you took the time to join us today. My name is David Scheffel, and I'll be moderating the program. We'll be discussing the impact of the Supreme Court's recent decision in Jesinoski versus Countrywide. Let me introduce our speakers. We have Joe Lynyak, who is based in our Washington, D.C. and Southern California offices. Joe has been a bank regulatory attorney for over 30 years. He has significant experience in the mortgage field. Joe is also co-chair of Dorsey's Consumer Financial Services Subpractice Group. We also have Eric Epstein, who is based in our New York office. Eric is also a member of our Consumer Financial Services Subpractice Group. Likewise, Eric has significant experience in the mortgage field. Eric has litigated a number of cases throughout the country involving rescission issues under the Truth in Lending Act. And notably, Eric attended the oral argument in Jesinoski versus Countrywide. For those of you receiving New York CLE, the code is ZJQ821. Again, the code is ZJQ821. Before I turn it over to our speakers, let me first set the stage for Jesinoski versus Countrywide. In January of this year, the court issued its decision in Jesinoski. Notably, the court addressed two important issues regarding a borrower's right of rescission under the Truth in Lending Act. First, the court held that a borrower need only serve the lender with written notice in order to exercise his or her 3-year right to rescind the transaction. In so doing, the court rejected the bank's argument that a borrower must commence an action for rescission within 3 years. This decision resolved a split among a number of circuits, ones that required a formal action be filed, and others that required only a written notification. Second, the court noted in dicta that the requirement of tender, namely in which the borrower must return the loan proceeds to complete the rescission, is not a strict condition precedent to enforcing a rescission notice. As we'll discuss today, these two issues impact a number of players in the mortgage field. In our program, our goal is to address 4 topics. First, we'll explain the reasoning and rationale behind the decision in Jesinoski. Second, we'll recommend what lenders can and should do when they receive a rescission notice. Third, we'll forecast what to expect from the Consumer Financial Protection Bureau. And finally, we'll recommend how lenders should adjust their practices in light of the Jesinoski decision. Let me now turn it over to Joe to discuss the key implications of the decision.
Well, good morning, everyone, or good afternoon, as the case may be. I'm a regulatory lawyer and very frequently will give advice to clients about going forward, the policies and procedures they need to use in order to conduct their businesses. And the first question which we have is, why do we really care about this decision? And the reason why we care about the decision is that prior to it, most rescission claims were resolved by judicial interpretations, that is, going through the courts in either the federal or state system and coming up with bright line tests whereby lenders had an idea of what it is they needed to do. Importantly, in just about every jurisdiction, there remained a requirement that a borrower return funds prior to the rescission becoming effective. And that ended up being a very, very useful leverage to the lender or the assignee, as the case may be. Now, I think it's important to understand that all the components of rescission are now back on the table. And I think that's really one of the really important points here that are going to come out of this. For the next couple of years, we're going to have probably consumers and consumer advocates challenging just about every aspect of the rescission process. And part of it, keep in mind, is that state courts in particular, and to a lesser extent federal courts, are simply not up to snuff in terms of being able to understand the Truth in Lending Act and Regulation Z. It is very, very complicated, and you can come out with very, very erroneous decisions, and those decisions have to take time to percolate up through the appellate system. And so what we're going to have to do is work through this until we get to the point of, again, creating bright line tests that are going to be useful to us in terms of operating our businesses. Dave, next slide, please. A couple of key implications for borrowers. Pre-Jesinoski, rescission was useful, not an overwhelming tool being used for people, but it was useful, and if you had the time and effort and also the resources to be able to litigate, a borrower could theoretically have a free house or free rent or free mortgage payments for a period of time. And there was certainly an incentive in that regard for the lender to come to the table to negotiate more favorable terms with the borrower. And that's how the vast majority of rescission cases get resolved, not necessarily through litigation, but rather through negotiation with borrowers by a lender having an incentive to be able to resolve a payment default. However, in the case of borrowers, again, depending upon where you are and how effective your lawyer would be, rescission claims could delay for years a default and foreclosure, and so a borrower could arguably live in their homes for a considerable period of time. Under the Jesinoski case, however, as I mentioned, it's probable that consumer advocates are going to be challenging every aspect of a rescission case, and therefore there's probably going to be a greater incentive on the part of consumers to raise rescission, to file rescission notices, and note that under Jesinoski, the borrower does not need to draft or file a complaint. That's one of the major holdings in Jesinoski. And then also, too, while there still remains an obligation of the borrower to return some of the funds, it doesn't have to happen immediately. Dave, next slide, please. Key implications for lenders. As I mentioned, in the case of a lender could rely upon the fact that the borrower has to return loan proceeds and therefore had to come to the table. That is now gone. What was clear in the Jesinoski case is that there was really the court said that there is no linkage between the common law right in rescission of returning proceeds. However, note that the statute, Truth in Lending Act, does contemplate that funds have to be returned. And so what we're going to have to be waiting for is emerging a rule that's going to be, again, the bright line test for us to be utilizing. Next slide, please, Dave. However, during at least the next couple of years, in the post-Jesinoski world, it's going to be much riskier for a lender to ignore or to reject a rescission notice. And that's because people are going to be alleging new violations of truth in lending. And as my colleagues who are litigators are going to be discussing, you're going to have to decide whether or not you want to promptly seek judicial relief and perhaps a declaratory judgment action as to whether or not the rescission is valid or is not valid. It is certainly more important than ever, once you get a rescission notice, to document that a borrower has received the requisite material disclosures and that the three-day rescission notice, the short-term rescission notice has been filed, and the requirements for rescission have been complied with. Just a quick review, what are material disclosures? Well, material disclosures are the correct disclosure of the APR with intolerance, the finance charge, the total of payments, payment schedule, and certain other disclosures which have to do with higher cost loans. And for those of you who are struggling right now with the TILA disclosures that are going to be kicking in a couple of months, it's interesting to note that the material disclosures that have to be still provided don't necessarily line up all that well with the TILA disclosure regimen that's recently been adopted. So I will stop there and we'll come back a little bit later to some additional advice, and I will now turn it over to Eric.
Thanks, Joe. As David mentioned earlier, one subtopic we would like to cover in further detail is the substance and reasoning of the Jesinoski decision. On the one hand, to be sure, the decision clearly represents a good outcome for borrowers. On the other hand, one also can look at the decision as being closely tied with the Supreme Court's earlier ruling in 1998 in the Beach case. Construing the two cases together, the Jesinoski decision can potentially be viewed in a somewhat different light. As background, in the Beach case, over 3 years after the origination of a loan, a lender brought a collection action against a borrower. At that point, the borrower, for the first time, raised rescission as an affirmative defense to the lender's collection claim. The lender responded by contending that the borrower was time-barred from seeking rescission because over 3 years had elapsed since the origination of the loan. By way of reply, the borrower contended that the 3-year deadline for asserting a rescission claim operates as a statute of limitation. A statute of limitation by all means applies to the commencement of an action, so here it indeed would have barred the borrower from bringing a new or independent action against the lender. However, a statute of limitation does not necessarily apply to the assertion of an affirmative defense. So it was argued by the borrower in Beach, the borrower's rescission defense was not time-barred, notwithstanding that the borrower was outside the 3-year window. Ultimately, in Beach, the Supreme Court sided with the lender. The court held that the 3-year deadline is not a statute of limitation because the statute, in the court's words, talks not of a suit's commencement, but of a right's duration. The Supreme Court, therefore, found that the 3-year deadline functions as an absolute deadline for exercising, in whatever way, shape, or form, the right to rescind. Now, on its own terms, Beach was a good result for lenders. But once the court found in Beach that the Truth in Lending Act does not deal with a suit's commencement, the result in Jesinoski was virtually pre-written, because it would have strained logic to hold in Beach that the statute, in the court's words, does not speak in terms of commencing a lawsuit, but then to hold later in Jesinoski that the statute at the same time requires a borrower to commence a lawsuit. Taking the cases together and the issues they presented, there potentially were only 2 alternative sets of rules that the court could have put into place. First, the court could have found, again, that the 3-year deadline operates as a statute of limitation. In that scenario, for purposes of asserting a rescission claim, a borrower would be required, indeed, to sue the lender. But potentially, the borrower could raise rescission as an affirmative defense for the entire life of a loan, which in turn could potentially impede any collection or foreclosure action ever brought by the lender with respect to that note and mortgage. Or, as a second alternative, the court could have found, and ultimately did find, that the right to rescind goes away entirely after 3 years, at which point the lender gets rock-solid security with respect to its mortgage. But until that time, the borrower can exercise the right of rescission by sending a notice or by commencing an action. The court in Jesinoski, in fact, ultimately decided on this second approach, in which, again, on the one hand, after 3 years, the lender's security is confirmed, potentially, but on the other hand, until that point, the borrower may be able to rescind via notice. Turning to the next slide. Beach and Jesinoski both deal with problems of statutory interpretation that in large part have their genesis in the history of the Truth in Lending Act. As originally promulgated in 1968, the Truth in Lending Act created two separate rights of rescission, each of which is codified in 15 U.S.C. 1635A. First, 1635A says that within 3 days of a closing of certain residential mortgage transactions, before the loan is funded, the borrower can cancel the transaction and can do so for any reason or for no reason. The statute calls that a right of rescission, but on a practical basis, it's really more akin to a borrower's remorse provision. The statute explicitly allows a borrower to exercise that right of rescission by notice. And that right is built into every mortgage loan transaction that is subject to the Truth in Lending Act. Second, the statute provides for an extended right of rescission, one which can be exercised potentially even after a loan has been funded. In this context, because the loan has been funded, rescission presents a more complicated proposition. Specifically, at this point, rescission means the lender must release its lien and unwind the transaction. Unlike the 3-day right of rescission, this extended right of rescission does not apply to every transaction that is governed by the Truth in Lending Act. Instead, it applies only if the lender failed to provide complete and accurate disclosures as required under the Truth in Lending Act, or failed to properly notify the borrower of the borrower's right to rescind a transaction within 3 days. With respect to this post-funding or extended category of rescission, the original statute, the Truth in Lending Act, as promulgated in 1968, was in some ways far more problematic for lenders because this extended right of rescission was not bounded by any deadline. Instead, under the 1968 iteration of the Act, if the lender's disclosures were deemed faulty and the transaction was subject to TILA, the borrower could rescind for the entire life of a loan. In 1974, Congress sought to correct that problem by bookending the extended right of rescission with a 3-year deadline, recognizing that it was improper for a lender to face such a degree of uncertainty for the entire life of a loan. And that 3-year outer deadline is now codified in a separate subsection, 15 U.S.C. 1635F. Fundamentally, both Beach and Jesinoski deal with the question of how to construe 1635A, which, as noted, was built into the original iteration of the statute in 1968, together with 1635F, which was added later in 1974. In terms of what the 3-year deadline means, and what steps a borrower must take in order to satisfy that deadline. Turning to the next slide. Regarding the specific issue of whether it is sufficient for a borrower to send a notice of rescission as opposed to commencing a lawsuit, there was never any doubt that the answer to that question was yes when a borrower exercises that right within 3 days of a residential mortgage transaction subject to the Truth in Lending Act. The contested or controversial issue was whether to export that notice rule to the extended rescission context. The problem presented was that the two scenarios, while similar in some ways, are also quite different from a policy and litigation perspective. In the context of a borrower's exercise of the 3-day right of rescission, rescission by notice has not been especially controversial for 3 principal reasons. First, that scenario does not lend itself as easily to abuse as a means for the borrower to walk away with the lender's funds. The reason being that Regulation Z generally prohibits lenders from funding a loan until 3 days have already expired and the lender has reasonable assurance that the borrower does not intend to exercise that 3-day right of rescission. As a result, in this context, the borrower typically would not have the lender's funds. So here, the borrower's willingness to tender after the lender unwinds a transaction pursuant to a borrower's exercise of the right to rescind is less likely to be a relevant or disputed point. More specifically, under the statute, if the borrower opts to rescind before 3 days have expired, the lender has 20 days to commence a process of first releasing the lien and second, returning any money that has been paid. Following that, the statute will require the borrower to return or, in the statute's terms, tender the lender's funds. And the statute allows a court to alter this sequence of steps depending on the facts and circumstances of a particular case. Now, theoretically, rescission by notice can raise the potential concern that a lender may be required to release a lien and return funds when, in the end, the borrower may not intend to return the lender's funds. But in reality, it's unlikely that the borrower would have the lender's funds at this point in terms of the exercise of the 3-day right of rescission, because, again, Regulation Z generally prohibits a lender from funding a loan until this window has closed and the borrower has opted not to rescind. Second, assuming that a transaction is indeed subject to the Truth in Lending Act and the right of rescission is properly exercised by a borrower within 3 days, it is less likely that there would be any defenses to rescission. So a lender may have little or indeed no incentive to litigate. Third, from a litigation perspective, the 3-day right of rescission by notice rule can help lenders because in predatory lending cases, borrowers often are heard to argue that there was insufficient time at closing to read or understand the transactional paperwork. And one response that potentially can be offered by a lender in that regard is to point to the borrower's subsequent 3-day window to further consider the terms and conditions of the transaction and potentially to cancel. Turning to the following slide, the 3-year extended right of rescission under 15 U.S.C. 1635 presents an entirely different set of issues and problems. Here, for three principal reasons, the notion of rescission by notice is more controversial. First, here you have a funded loan, and together with that, a borrower who may already be in default. So a lender naturally will be concerned about a borrower strategically rescinding to potentially walk away with a free house or the lender's money. Specifically, once the lien is released, the borrower may refuse to tender or be unable to do so, and the lender may find that it has no practical ability to collect on a judgment against the borrower in the absence of a lien on the property. Second, the extended right of rescission applies, as noted earlier, only if the borrower was materially misled by faulty disclosures. Resolving that issue often requires litigation. To be sure, the closing papers in a residential mortgage loan transaction typically will include certain documentation signed by the borrower acknowledging receipt of such disclosures. However, under the statute, that only operates as a rebuttable presumption. And in a litigation context, a borrower often will seek to rebut that presumption by first simply averring that, in fact, he or she did not receive disclosures or did not receive sufficient copies, or by raising a technical issue regarding the accuracy of disclosures. The concern is that for practical purposes, the idea of rescission by notice will abrogate the lender's opportunity to contest those issues in court before the lender's obligation to effectuate the rescission kicks in. Third, requiring a borrower to sue can, in the end, help to deter some frivolous rescission claims because, as Joe discussed earlier, the borrower will be forced to articulate, under penalty of perjury or sanctions, a reasonable basis for rescission consistent with the terms of the Truth in Lending Act. So, exporting this notice rule from the 3-day context to the 3-year arena, while arguably consistent with a plain language reading of the statute, is perhaps not what Congress ultimately intended, given that the purpose of 1635F was to give lenders a greater and a reasonable degree of certainty regarding the validity of a lien. Turning now to the next slide. This ambiguity in the statute, as David touched upon, led to a circuit split. A minority of circuits held that the 3-year deadline should be seen as a deadline for bringing suit. Other circuits, a majority of those that weighed in on the issue, held that notice is sufficient. The particular facts of the Jesinoski case put this circuit split directly into issue, ultimately requiring the Supreme Court to resolve this circuit split. In the Jesinoski case, the Jesinoskis rescinded precisely 3 years after the origination of a residential mortgage loan transaction, which was subject to TILA. They did so by sending a letter, or in other words, by notice. The Bank of America rejected that rescission notice, and at that point the Jesinoskis sued to enforce their purported notice of rescission. The Supreme Court sided with the borrower. In its reasoning, the court held that there is just no basis in the plain language of the statute for supposing that rescission in the 3-year context would work any differently than in the 3-day context, where a borrower can rescind by notice. Therefore, as the court held, the borrower is not required to sue in order to exercise the extended right to rescind. The borrower can rescind by notice. As a related point, as David alluded to earlier, the court also confirmed that, as in the 3-day context, the borrower here is not required by statute to tender as a prerequisite to exercising the extended right to rescind. The borrower's obligation to tender typically kicks in after the lender unwinds a transaction, although a court can alter that sequence of steps based on particular circumstances of a case. At oral argument, the justices recognized the potential for abuse of a notice rule after a loan has already been funded. Justice Scalia, for example, opined that it was, in his words, difficult to believe that Congress intended to create a system in which a lender's secured interest is converted into an unsecured interest, quote, simply because somebody comes up almost 3 years later and says, you didn't give me 2 copies of this particular document. But interestingly, those concerns don't surface in the decision, presumably because the court felt that the plain language of the statute was sufficiently clear. On one level, Jesinoski seems like a fundamental change in how rescission claims work. But another perspective is that the change is not that momentous. Pre-Jesinoski, if a borrower requested rescission of a loan and the lender recognized that the borrower indeed had a substantive right to rescind, consistent with the provisions of the Truth in Lending Act, the lender might opt to allow rescission to avoid litigation that would be futile or expensive. Post-Jesinoski, that still may be the optimal response, where a borrower's right to rescind appears to be indisputable, and where it is clear that in the end, the borrower will be willing and able to tender. Pre-Jesinoski, if the parties disagreed as to the validity of a borrower's rescission request, litigation could ensue. And now litigation probably will continue to be the mode of resolving such disputes. What has changed, in a sense, is that pre-Jesinoski, the borrower more likely would be the plaintiff in an action to rescind, an action to enforce the rescission, or to seek damages for a lender's failure to comply with a rescission request. By contrast, now the lender more likely will be the plaintiff in an action that seeks to declare a rescission notice null and void. And turning to the next slide, David, I think you'll cover this slide.
Thank you, Eric. That was an excellent historical analysis of Jesinoski. The next topic is what to do upon receipt of a rescission notice. The first thing that you should do is review the notice and see if it's valid and whether you have any defenses to rescission. For example, was the notice sent within 3 years? If it was not sent within 3 years, you have an absolute defense and can reject the notice outright. If it was sent within 3 years, you need to take a close look at the Truth in Lending Act disclosures to see if they were issued properly. I predict that in most cases the notice will not be valid as the disclosures were likely proper. As Joe mentioned and Eric mentioned, in most cases a defaulting borrower is using the rescission claim as a strategic defense to delay foreclosure and stay in his or her home. Second, you should decide whether to honor the rescission. Or if you decide not to honor the rescission, you should decide whether to sue the borrower. Later in the presentation, I'll discuss in greater detail the pros and cons of the various options that a lender has when it receives a notice of rescission. So let me now turn it back over to Eric.
Thanks, David. So as David mentioned, one issue presented now is, in a particular case, whether there are any substantive and valid defenses to a borrower's rescission request, which may now take the form of a notice. In that regard, perhaps the threshold question will be whether there ever can be a valid defense to any rescission notice post-Jesinoski, or whether a notice is a rescission. The answer, as emerged in the briefing and argument of the Jesinoski case before the Supreme Court, is that indeed there can still be defenses to a notice of rescission. In particular, at oral argument, Justice Kennedy posed the question, suppose a bank thinks that a notice of rescission in a particular instance is completely baseless. Does the bank still have to act within 20 days in accordance with the rescission request? To which the CFPB's counsel responded, a lender is going to have to make a judgment about whether it thinks the notice is valid. From there, if the lender comes to the conclusion that a notice of rescission is untimely or otherwise invalid, and if the lender is right, then the lender does not have to comply with the notice. As the CFPB's counsel put it, in our view, an invalid notice of rescission that is untimely has no effect. It puts no requirement on the lender to do anything. Procedurally, if a lender has received a purported notice of rescission that in the end the lender believes to be invalid, the lender has two options primarily, as explained by the CFPB. On the one hand, the lender can simply wait to be sued, if ever, by the borrower. Here, however, the lender is taking a gamble of sorts because, as expressed by the CFPB's counsel at oral argument, if the lender guesses wrong, then it may well be that the lender will subsequently be held liable for damages for guessing incorrectly and for failing to follow the unwinding procedures under Section 1635B when it should have done so. The second alternative, as the CFPB expressed in its amicus brief, is that a lender can affirmatively sue the borrower to resolve the dispute and specifically to seek to have the purported notice of rescission declared null and void. As the CFPB wrote in its brief, a creditor who receives a notice of rescission within the Section 1635F period can immediately resolve any uncertainty about the status of the underlying transaction by filing suit seeking to declare the notice invalid. More specifically, I would offer that there are likely four primary defenses that could be invoked on the part of a lender to object to a borrower's purported notice of rescission after Jesinoski. First, depending on the circumstances, a lender might argue that the note and mortgage at issue are not subject to the Truth in Lending Act, and that, as a consequence, TILLA's rescission provisions do not apply. For instance, in a particular case, a lender might contend that the loan represents a purchase money mortgage, that it is not secured by the borrower's primary residence, or that it constitutes a refinancing by the same original lender, not in excess of the original principal balance of the loan, and that for any of these reasons, TILLA does not apply and the borrower never had a right of rescission. Second, a lender potentially might contend and demonstrate that the underlying disclosures consistent with TILA were accurate and sufficient, and that the extended 3-year right of rescission therefore never kicked in. Third, a lender, depending on the circumstances of a case, might argue that a borrower is evidently unable or unwilling to tender. In the briefing and argument of Jesinoski, the CFPB took the position that if a borrower is in fact unable or unwilling to tender, it may indeed be appropriate for a lender to seek judicial relief in that regard. And from a litigation perspective, the fact that a borrower has defaulted, which will correlate with many rescission requests, is arguably evidence of a borrower's inability to tender. In point of fact, in the Jesinoski case, the lender's alternative argument to the district court on the lender's motion to dismiss, which ultimately wound its way up to the Supreme Court, was that the borrower lacked the ability to tender. The district court did not rule on that issue, since the court found that the plaintiff's failure to sue within 3 years was dispositive. But following the Supreme Court's recent decision, the lender has asked the district court for a window of time in which to consider renewing the argument that the borrower's inability to tender is independently fatal to the borrower's rescission claim. Lastly, if a borrower's rescission notice is not served within the window of 3 years from the origination of a loan, that as well can constitute a potential objection or defense to a notice of rescission. Turning now to the next slide. Depending on the lender's determinations of these questions regarding the merit of a notice of rescission, the next issues become, first, whether to rescind, and secondly, whether to sue the borrower. From there, one can imagine at least 4 approaches. First, the lender could rescind and sue. Second, the lender could rescind, but refrain from bringing a suit against the borrower. Third, a lender could refuse to rescind and, coupled with that, commence an action against the borrower. And lastly, the lender could reject a notice of rescission, refuse to rescind, and also refrain from commencing an action from the borrower and take a wait-and-see approach with respect to whether the borrower will commence an action against the lender in that regard. One notable point with respect to these options is that pre-Jesinoski, a lender's claim against a borrower typically would be venued in state court, since the claim, at least in the first instance, might be purely an action on the note or mortgage for collection or foreclosure. Now, however, having received a rescission notice or purported rescission notice, a lender potentially has an option of suing in federal court, with the lender's Truth in Lending Act argument forming the basis for invoking federal question jurisdiction. And some lenders may consider federal court to be a more favorable forum, especially if the dispositive issue will be interpretation of a federal statute, specifically the Truth in Lending Act. Next, I think David will talk more specifically about the pros and cons of these options and what a lawsuit against the borrower might look like in terms of the lender's claims.
Thanks, Eric. With the time constraints we have, I'm going to quickly cover slides 16 and 17. Slide 16 sets forth the various theories of liability that a lender has when it receives a notice of rescission. These theories range from breach of contract to a declaratory judgment that the rescission notice is not valid, I won't spend much time on this topic as the slide is fairly comprehensive and we're got about 15 minutes left in our presentation. So let me just note that there are a number of theories that a lender has or can invoke in order to address and resolve a notice of rescission. Quickly turning to the pros and cons of the various options that a lender has when it receives a notice of rescission. Eric identified the 4 various options that we have: comply and sue, comply and do not sue, do not comply, sue, do not comply, and do not sue. And without going into detail of each of these items, I just want to identify the one that makes the most sense. And in this case, it's the third option, which is to file an action seeking a declaratory judgment that the notice of rescission is not valid, and then do not comply with the notice. And the reason why this makes most sense is, first, the lender will resolve the validity of the rescission notice right away. Second, the lien is preserved. And given many borrowers won't have the money to tender the funds and essentially return the loan proceeds to the lender doesn't want to rescind the transaction and lose its lien. So this third option puts the lender in the strongest position to address a written notice of rescission and maintain its lien. In addition, given the dispute involves the Truth in Lending Act, a federal statute, it gives the lender the option of having the dispute heard in federal court, which is a more favorable forum than state court. Let me now turn it over to Joe for the remaining 13 minutes. Joe.
Oh, thanks, David. We are going to go through a couple of questions based upon our views of these various decisions and give you some ideas to take back and to think about. Eric, I think, covered very nicely the issue of do you have a potential defense, and I'm not going to go into that again other than the fact that you go through a laundry list of things and determine whether or not there are any defenses that are valid. But then the question comes up, what do you need to do if you think you have a valid defense? And I think here the pre and post Jesinoski status has not changed. If the defense is valid, you really don't have to do anything because your mortgage lien remains valid, and effectively you say, come on and get me because I think I've got a defense here, because the debt remains clear, the lien remains clear. However, you may want to think about notifying your mortgage loan servicer of the existence of a rescission notice, and we are going to talk about that in just a moment. Let's go to the next slide, please. What is a rescission notice? Does the borrower have to use the official form? Does the notice have to use the word rescission? Well, it must be in writing. It must be delivered. Mailing it makes it effective immediately. Just about every other type of notice makes it effective when it's received by someone. And the question arises whether or not the delivery to a servicer or to the assignee is a proper notice. And there's a nuance here that I think the audience needs to understand, and that is it is very clear under the Truth in Lending Act in Section 1641C that you can rescind as to assignees. And so if you send a notice to an assignee and you know who the assignee is, the rescission is effective. Now that section also goes on to say that based upon transfer notices that we're all pretty used to under RESPA and so forth, you have to give a notice to the borrower as to who your agent may be if you're an assignee. And you need to think through whether or not you want to make the servicer your assignee and hence your agent. And here's where it gets somewhat complicated, because a servicer may not be your agent under state contract law. And so you have to think about that. And so therefore, giving a notice to a servicer may be deemed to be given an assignee notice for purposes of rescission, or it may not. And likewise, the issue is somewhat unclear as to whether or not, if a loan is sold in the secondary market and a notice is sent to the original creditor, whether or not that original creditor effectuates a proper rescission. And again, that's something you're going to have to check with existing case law in your jurisdiction to determine whether or not that works or not. But if the loan has been assigned, you clearly need to take a look at the issue of whether or not you want to designate the servicer as being your agent. And I think also Regulation Z makes pretty clear that all you need to do is to say, I cancel in writing, proper delivery, and you've got a rescission. The question arises, and this is something where perhaps down the line we might get some help from the CFPB, as to whether or not we should require additional information in order to allow an assignee who may have several 100,000 mortgages in their portfolio to properly identify who has been rescinding, what is the status of the borrower, what is the loan number, and so forth. And certainly that information certainly helps in terms of being able to respond properly. Turning to the next slide, does the 20-day deadline for unwinding a transaction apply to a borrower's exercise of an extended right of rescission? And does the lender have to unwind the transaction within 20 days upon receiving a rescission notice? Well, the commentary states that as long as you commence the 20-day period, you can exceed the 20-day period. And from a practical standpoint, most large lenders can't do anything within a 60-day period, much less a 20-day period. And this 20-day period is probably totally impractical. But I will note the fact that you will probably have people on a state-by-state basis taking runs at the issue of whether or not compliance has to be completed. Also, too, again, there are a lot of relatively extreme positions that you may deal with initially because the courts may be confused about them, including the issue to confront as to whether or not the failure to comply completely negates the consumer's right to have to respond and provide funds back to the borrower. And some consumer groups also take the position that upon the failure to comply with the 20-day notice, the debt itself is extinguished. Certainly an extreme position, but it has been litigated, and I would suspect that it will be litigated again. If the rescission notice is self-executing, does the mortgage remain valid until the lender releases the mortgage? And here we're talking about the lien on record. Well, according to Truth in Lending, the lien is void. However, I think what you have to do is you're going to have to take a look at state real property law to recognize the validity of the real property lien on the title under the particular recording statute. Now, one of the things that actually may end up being helpful here is that there's a thing called slander of title, and that's when the borrower can come and sue you saying, you have besmirched my title and therefore you owe me damages. Well, in most states, under the concept of slander of title, there is a conditional privilege, and that is if you recorded a lien against property, against real property, and you had a right to do so, that is a conditional privilege and should exculpate you from liability, provided that when you make the determination that the lien has to be removed, you do so quickly. Another issue to think about is what is the statute of limitations for a borrower to enforce the notice and seek damages? I think the answer under Truth in Lending is that in the extended Truth in Lending position, it's probably going to be 1 year. It's not going to be another 3 years. But most Truth in Lending violations give you an opportunity to jump back into state law. And when you jump back into state law, the consumer may have more time than merely 1 year to allege a violation. Turning to the next slide. And the next slide is, and this very quickly, If you are in a non-judicial foreclosure state, such as my favorite state, California, take a look at Code of Civil Procedure 726 and the implication of the one action rule. I would strongly urge consideration as to whether or not, if you seek a declaratory judgment regarding the status of your lien, it doesn't implicate the one judgment rule. And for those of you out in California, you probably are quite aware of this, but it is an open issue and I suspect will be litigated. Next slide. What to expect from the CFPB? I think we're going to expect the fact that the CFPB is going to be relatively active in this regard. And unfortunately, we really switched horses here. In the past, when the Federal Reserve Board had control of the Truth in Lending Act, it would never get involved in litigation between parties, and we as lenders would oftentimes urge them to do so, and they would have a hands-off approach. The CFPB has clearly telegraphed their intention to support consumers, and I suspect that in the future, in terms of this litigation arising out of the meaning impact of rescission as we go forward, we're going to see the fact that the CFPB may be acting as amicus in cases and may be acting in a manner that's adverse to the industry. They can't help themselves. Anyway, those are some thoughts. David, you're going to wrap up now.
I am. Yeah, Joe, thanks. Just want to piggyback off that last point you raised on the CFPB. Really is a demonstration of the CFPB's major role in helping consumers in Jesinoski, given the amicus briefs that they filed and argued at the Supreme Court, as well as in the circuit courts. They played a major role in the result. In the final two slides, I want to briefly address the topic of how to prepare for rescission notices post-Jesinoski. From a litigation perspective, I expect that borrowers and especially consumer lawyers will send written notices of rescission early and often. It's an easy thing to do, and it preserves a powerful claim to delay the foreclosure process and thereby keep a borrower in his or her home. So we'll definitely see an uptick in these notices. Banks and lenders need to have a protocol that they follow when they receive these notices. For example, there should be systems in place that promptly identify and process these notices. You need to determine if the notice falls outside the 3-year time period and therefore is clearly invalid and can be rejected, or if the notice falls within the 3-year time period, you need to audit whether the Truth in Lending Act disclosures were proper, mindful that the results may be discoverable unless the review is done by counsel. Based on the current landscape, from my perspective, the best option for the bank or lender is to file an action, preferably in federal court, seeking a declaratory judgment that the notice of rescission is not valid, and then do not comply with the notice. The advantages of this option are that the lien remains intact and the rescission notice will be resolved right away. The bottom line is that until 3 years have elapsed, a mortgage is only as secure as the lender's proof of compliance with the Truth in Lending Act. Again, for those of you receiving New York CLE, the code is ZJQ821. Again, ZJQ821. And on that note, this concludes our presentation. To all the listeners who joined us today, thank you so much for joining us. If you have questions, please send an email to Eric, Joe, or myself, and we'll respond right away. Or if you want to send an email to dorseyu@dorsey.com, which you can find on the first page of the PowerPoint presentation, we'd be happy to respond. So thank you again.
Ladies and gentlemen, that does conclude the conference call for today. We thank you for your participation and ask that you please disconnect your lines.